Today, we are going to discuss the subject of non-disclosure agreements or confidentiality agreements. The coronavirus has changed a lot for all of us. Almost every corporate in the world has been affected by the latest coronavirus. The most common issue that we are facing is the lockdown and work from home. We have all been accustomed to working from an extremely secured workplace in our corporate offices. And we never really imagined that there would come a time and a situation where we would have to actually leave the comfort of all that office infrastructure to move to working from home. And the issue with working from home, while it may sound, of course, comfortable, is each of our respective employees are working from their own respective homes. They are out of the secured environment of the office infrastructure, which means, and this is the crux of my message today, data and information which is confidential, which needs to be secured, is now out of our secured environment. And what do we need to do to secure this data, which is now beyond the scope of our secured environment? The biggest task is not only managing and coordinating staff and operations working from various remote locations from their houses, but the issue that we're really concerned about is making sure our clients' data and information, which is confidential, is maintained in that confidentiality, and we have to ensure that this information is not leaked or disclosed illegally. Working from home would entail working from laptops or other devices from the individual employee's house. Some of these laptops have been provided by the corporates. In other cases, where we have not been able to provide employees with laptops, they are working from their own laptops, their own phones, or their own computers. The issue is we need, as a company, every company needs to ensure that the information which is now being passed out to them to take home is being maintained, is being secured as if it was secured in our corporate offices. Therefore, I have come up with this topic of discussing non-disclosure agreements or confidentiality agreements. Non-disclosure or confidentiality agreements are such agreements that an employer needs to sign with the employee in order to protect the company, the company's interests, and the interests of the company's clients. A confidentiality agreement or a non-disclosure agreement is a contract or a contractual provision whereby a person agrees, promises, or undertakes that he or she will not disclose trade secrets, confidential information, or proprietary information to any person except by the due process of law. It is a sort of undertaking or it's a contract whereby the employee undertakes and indemnifies the company that he or she will not leak out any such confidential information, trade secrets, or proprietary information that will come into his or her possession by virtue of their employment. Now, what are the types of information? And these are clauses that you would incorporate into your NDA agreements. Confidentiality of information. This is the main thing that we are talking about. Now, the question is, what do we want to really incorporate into all of this? What are the terms that we would like to put in? Firstly, trade secrets. What are trade secrets? Any confidential secret of trade, which is a proprietary custom of trade, which comes into your knowledge or your possession as an employee by virtue of that particular position that you enjoy in that organization. Any secret which is known only to your employer and which is known only to your employer or the company's clients. This is a trade secret. Something that is not known to the general public or something that is not out there at large. The next thing is confidential information. Confidential information may not always amount to a trade secret, but it is information that needs to be kept in the strictest confidence. It could be client information, it could be information about your client's accounts, about clients' advertising strategies, clients' business strategies, whatever the case may be. It is information that is strictly confidential to the client and which has been in the course of that business transaction passed on to your company, and you have access as an employee to it by virtue of that employment. Proprietary information is another major topic that we discuss in NDA and confidentiality agreements. Proprietary information is information that may have been discovered or developed in the course of that business transaction. It is information that is developed in the course of a transaction between the company, its client on the one hand, and the employees on the other hand. So this information is extremely confidential information. And this information has to be secured. One has to ensure that this information does not leak out because it could cause severe damage not only to the company but to the company's clients. Another very interesting clause that comes up in all confidentiality agreements or non disclosure agreements is the indemnity clause. Now, what is an indemnity? An indemnity is an agreement or a clause in an agreement that asks a person to keep another person harmless from losses which may occur on account of some act or omission. Now, where does this indemnity clause apply to NDAs and confidentiality agreements? In confidentiality agreements or non disclosure agreements, there is always an indemnity clause where the employee indemnifies the employer for any breach of the NDA or confidentiality agreement, any breach whereby information which is confidential, proprietary, or a trade secret is disclosed by such employee. As an employee, you need to be careful to ensure that you do not disclose such information because you are protecting your employer by virtue of this indemnity clause from any losses, any damage that may be caused to him and the company. And sometimes it extends also to the client of the company in case of breach of the NDA, in case of leakage or disclosure of such information. Another very important clause that comes into NDAs or confidentiality agreements is the duration of the agreement. As an employer, you need to see how long you need to keep or enforce this duration. And as an employee, you need to see what is the duration of this confidentiality agreement. Most confidentiality agreements are for the course of your employment, but there are also cases where the confidentiality agreement for trade secrets and proprietary information may last even beyond your employment. What you generally need to do is information that is passed on by an employer in the course of your employment should not be passed on even to your future employer who may be a rival of your present employer once you change jobs. Therefore, it's very important that you strictly maintain confidentiality agreements to secure the employment, to secure the company, and to secure the company's clients. We are now raised with another fundamental question, the question of statutory disclosure, and when you as an employee are compelled to disclose information that you have signed that you would not disclose by virtue of the NDA or your confidentiality agreement. There are only legal or statutory exemptions where you are under statutory obligation or where you are under duty of cast upon you by the law to disclose information. And these are only, and I repeat, these are only in cases where it is being given to investigating agencies such as the police by virtue or in the course of an investigation which is being carried out by them. Secondly, when there is a court order and it's in compliance of an order or a direction of a court of competent jurisdiction. I now come to remedies available for breach of such NDA agreements. In case an NDA is breached by your employee, in case a company has an employee that has leaked out information, what are the legal remedies available to such an employer? Firstly, he needs to move court. Firstly, he needs to get interim orders prohibiting further leakage of information or further disclosure of such confidential information or trade secrets. Then you need to proceed with the litigation in order to prove the violations, and thereafter you can sue for compensation and damages for the losses that may be caused to the company by virtue of the negligence of the employee or the willful disclosure of confidential information, trade secrets, or proprietary knowledge. The next question that we're drawn to is, as an employee, what are you expected to do? What do you do when your employer asks you to sign a confidentiality agreement or a non-disclosure agreement? You are expected to keep whatever information is given to you by virtue of your employment, whether it be confidential information, client information, proprietary information that has come in out of development of new concepts or ideas in your employment, or information or trade secrets that may have been passed on by your employer, which has been received by him from the client in strict confidence, and make sure you do not disclose it to anyone, whether formally or even casually with your friends while you chat over a coffee, because those friends of yours who are really close to you may actually be employees of other competing companies. When we get to the issue of non-disclosure or confidentiality agreements, you're going to ask me, where do we find these agreements? How do we get into them? Have we already gotten to them? Now the question is, I do hope each and every one of you has got these agreements duly executed and signed with your employees at the time you employed them. There are various ways in which you have non-disclosure or confidentiality agreements. More often than not, these non-disclosure or confidentiality agreements are not expressed or separate agreements, but these are clauses that form part of your main employment contract or employment agreement. In more specific cases, companies have entered into separate agreements, separate non-disclosure and confidentiality agreements with their employees. This is the ideal case that you would want yourself to be in. But if not, even if you have the non-disclosure or confidentiality clause in your regular employment contract, you are more than safe and secure. The other way of doing this, and this is another very common way of doing it, is companies engage employees or employ staff using only an employment letter, and the terms and conditions of that employment are generally contained in a service manual or a service handbook or your terms of service, or by whatever nomenclature you may choose to call it. Now, in such a case, what you need to look for very carefully is, one, has there been a reference to these terms of service or the service handbook in the appointment letter of the employee? Secondly, and very importantly, were these terms of service or the service manual, as you may call it, or whatever you call it, has that been shown to the employees prior to them accepting the employment? And thirdly, do you have written acceptance from the employee as to your service manual and your employment agreement? Because remember, this revolves around the principle of an agreement, and therefore acceptance is extremely crucial. Therefore, you need to enforce this acceptance by the employee. The other issue that we're all going to face is many of us have never really anticipated this concept of work from home. Right till COVID-19 struck us, we really never thought of people working from home. We always thought of large corporate offices, the glamour of sitting in a highly secure environment. And we never expected some external force, some force measure, a topic I will take up in a separate episode, to really come and shatter what we had in place. But now that it has done so, what are we going to do? Is it too late? And that is what each of us have to look back at, because we need to go back to our service records. We need to go back to the details of these employees and see whether they have accepted such non-disclosure agreements or such non-disclosure clauses in their agreements. And if not, what do we do? I would suggest as soon as possible, even if this could be done through email and virtual conferences, get some sort of a non-disclosure agreement or a confidentiality agreement, or even merely an undertaking from the employee stating that this confidentiality will be maintained or non-disclosure will be secured. The next question you're going to ask me is, how do we get it executed? Well, simply have an individual copy made for each employee with their names, with their details, have it sent across, hopefully in a PDF format, have them accept it by virtue of an email, either through their registered email address with the company or their official company account if they've been provided with one. And as soon as we are back to office life, whenever the lockdown has been released, have the same physically signed and incorporated into the records of that employee. Now the question is that everyone keeps asking, why sign such NDA agreements? NDA agreements are not, and you should look at it this way, I repeat, are not employer-centric agreements. They are agreements for the benefit of all. Yes, while they may secure the business interests of the employer, the sole purpose of an NDA is not only the business interest of the employer or the company, but also the business interests and the interests of the company's clients on the one hand and its employees on the other. Because a company that is safe is a healthy working environment also for its employees. This is the only way forward, and this is the way you will ensure that you are safe and you restrict your liability from what action could be sought by your clients should an employee leak confidential or secured information.